Good afternoon, everyone, and welcome to Case Studies in Defender Civil Program Partnerships. My name is Emily Flanagan, and I'm here at NLADA, and I'm very excited to be sharing this webinar with all of you, as well as introducing our speakers for today. This webinar is presented as a part of our Partnerships That Work series, which is a 5-part series helping civil and defender stakeholders to better understand the ins and outs of connecting their programs to federal resources. The series is presented jointly by our Defender and Civil Legal Services divisions as a collaborative effort to connect stakeholders across the civil and criminal justice landscapes to resources, partners, and to spark innovation. You can learn more and register for any of our upcoming sessions or see slides, videos, and materials from previous sessions on our website. Lasting through November of 2017 at least, we'll be covering topics from the granular to the expansive and offering opportunities for participants to learn from those programs who have succeeded in navigating the world of funding and partnerships successfully. Today, I'm joined by Jamie Rodriguez from the Public Defender Services of the District of Columbia, Sharon Dietrich from the Community Legal Services of Philadelphia, and Richard Cazzola from LAF Chicago. Catherine Huber unfortunately was called away and will not be able to join us today. During their presentations, each of our speakers will share a little bit more information about the lessons learned related to building strong partnerships between defender and civil legal aid programs. At NLADA, we believe that holistic defense is the best way for our stakeholders to have a lasting positive impact on their communities, and we know that many clients and families are shared across these two groups. During our session, should you have any questions for presenters or for NLADA, you can go ahead and type those into the chat box in your WebEx platform. Additionally, as we're wrapping up, please keep in mind that we're currently scheduling our 2018 webinar topics series. So should you have any topics that you'd like to learn more about, go ahead and include those in your feedback at the end of the session. And with that, I'll hand it over to Sharon.
Thank you, Emily. Hello, everyone. Good afternoon. I'm with Community Legal Services of Philadelphia. As you were told, I'm the litigation director here. I just celebrated my 30th anniversary at CLS. CLS is the bigger and older of the civil legal aid programs in Philadelphia. We are not LSC restricted. Our partner program is Philadelphia Legal Assistance, which is the LSC recipient in Philadelphia. But the fact that we are not restricted really has very little to do with the collaborations I'm about to talk about. But just to give you some background on our program. We are fortunate to have a really outstanding working relationship with the Defender Association of Philadelphia. And that's what I'm here to talk about today. So why does this relationship work so well? Well, on the first slide, I identified a number of conditions that really facilitate our partnership with the Defender Association. And the first one that I think has some importance is that we are almost co-located. CLS is on Chestnut Street. The Defender Association is on Sansom Street. They basically back up against our building. So when a client comes to CLS with a problem that is more appropriately referred to the Defender Association, it's easy to send them around the corner. And the same is true vice versa, of course. This is really good for clients because they often or misidentify their legal issue, understandably, because these are complicated things to identify. And so they do often go to the wrong place. But it also makes it easier for us as lawyers to speak with each other and get together for meetings every now and then. Many times there are discussions about civil programs co-locating, but I will say that our experience having the Defender Association around the corner really raises the question of whether purposefully trying to be located in the same area isn't a good strategy. I would submit to you that it is. The second condition that I think makes our partnership work so well is that CLS does a fairly robust reentry portfolio on all kinds of different legal aid specialties. We deal with reentry and criminal record related issues in our public benefits practice, in our child welfare practice where we represent parents dealing with child welfare agencies, in our housing practice, but particularly in our employment law practice, where we have been helping people with criminal records for at least 2 decades. Currently, of the 1,500 people that come to CLS on employment intake every year, a full 1,000 of them, 2/3, come for help with their criminal records because they're finding that to be a major bar for employment. So that is the single biggest area that we work on in employment. And one of the things that we do there that clients value very much is expungements where possible, and I'll talk more about that later. But this type of practice that deals with criminal record-related issues really has made a lot of common ground with the Defender Association, and I think that's helped facilitate our relationship. The next thing I wanted to mention is that we've had a nice cross-pollination of people between the two organizations. CLS has hired people from the Defender Association to work as staff lawyers. We've had many interns who've gone to work at the Defender Association after they graduate from law school, because unfortunately for us, there tend to be more jobs at the Defender Association than at CLS. But we have many friends who've moved from our office to theirs. And then finally, we have cross board membership. So one member of my employment law staff sits on the board at the Defender Association, and we have a client board member who, in fact, was a client of mine, not only sits on the board at CLS, but also on the board at the PD's office. So I think that's very helpful. And the final thing I wanted to mention is that our executive directors have a very nice working relationship that they are very conscious of. They meet together regularly. They occasionally release statements together on occasions like the issues in Charlottesville. They see each other as peers who have quite a lot to say to each other, and they make sure that they nurture that relationship. In case you're interested, the Defender Association is run by Keir Bradford Gray, and my boss is Debbie Friedman. So those are the conditions that lead to the collaborations that I'm going to discuss next. So obviously one thing that we do, especially since we are so closely located, is we make referrals going in both directions. Certainly people come to CLS and have open bench warrants and that we are able to refer over there. And by the way, cut through some red tape sometimes to connect people with lawyers that would be very difficult for them to access on their own. But also the lawyers consult with each other. So if I have a question about an expungement issue that I don't know about, or about a criminal law issue, or maybe what a grade of a certain offense is, or what the outcome of a particular case is, if something complicated I don't understand, I can find folks at the Defender Association who will give me some time to work through those things, and the other way around as well. We provide trainings for each other. CLS has trained the Defender staff numerous times on collateral consequence issues, and they have been over in our office to talk about criminal law issues that our staff needs to know about. as I mentioned, expungement is a major source of practice in my program and the employment law unit for both adults and juveniles. We really took up the mantle from the Defender Association. They were one of the maybe minority programs in the country to provide expungement practice. And frankly, when we started working on criminal records and employment, we sort of let that area go to them because we felt like we had plenty to do raising Title VII claims and all kinds of other issues and claims around criminal records and employment. But eventually we figured out that expungement is such a hugely important remedy for our clients, and that we couldn't do a holistic representation of people with records if we didn't practice in that area. So we did decide some years ago to take it on. And the public defenders who practiced in expungement court essentially taught us how to do that. And that's true not only on the adult side where we started, but also on the juvenile side where expungement is quite different and frankly fairly laborious. In addition to both showing up in expungement court, we are stakeholder partners, so occasionally the First Judicial District of Pennsylvania is considering how to change the practice to make it more efficient, or more likely we are pushing on them efficiencies that we think will make things better for our clients. And the Defender Association and we are certainly partners in that kind of institutional advocacy. I wanted to mention, since funding is part of the discussion here, that certainly one of the sources of funding that we at CLS have found for our expungement work includes various public sources out of the workforce development system, such as WIOA, the workforce development money, TANF funds. We just recently started a new grant paid for by our state welfare department out of TANF funds to help clients who receive TANF remove criminal record barriers. And even SNAP, I should have put that on this slide as well. There's employment and training money there that is actually supplementing our TANF grant. So those are some sources to look at if you are interested in getting into expungement. And I should add that my program in Philadelphia, CLS, participates in the National Clean Slate Clearinghouse, by which we try to facilitate expungement law work around the country among both legal aid, civil legal programs, and defender programs. So if you're interested in that, particularly being on our listserv to have access to others working on these expungement issues, sealing issues, send me an email and I'd be happy to add you or tell you more about the National Clean Slate Clearinghouse. All right, final slide. Final things that we do together. We actually even occasionally litigate together. So one area in which we worked quite closely was on criminal debt when that first became an issue in Philadelphia in 2010, I think it was. And we knew nothing here in our civil side about bail forfeitures, but we knew that clients were getting letters telling them that they owed the court $40,000 because they missed a court date in criminal court. And so, especially since we were already practicing in criminal court with the expungement practice, this court debt issue seemed to be another one that we should take on for our civil clients, since it seemed like a post-conviction, civil-oriented problem. And indeed now, many programs are looking at court debt as an important thing they can work on. So we didn't know the first thing about bail forfeitures or practice around bail forfeitures, and the Defender Association was instrumental in helping us get up to speed on that. And eventually, part of what we did, in addition to litigating individual cases in the Criminal Justice Center, is that we brought a couple of cases up to first our Superior Court or Intermediate Appellate Court, and then finally the State Supreme Court, challenging the way those bail forfeitures were being done. And the Defender Association not only helped moot us for those appeals with their very fine appellate unit, but also gave us great background on what we needed to know for the appeal. So ultimately, we were not successful in the litigation on that issue, but I'm happy to say that our overall advocacy did ultimately lead the First Judicial District to write off over $1 billion of bail forfeiture debt that went back to the 1970s. So our clients are no longer burdened with that. More recently, one of my colleagues at Philadelphia Legal Assistance had an unemployment insurance case that she is trying to take to the state Supreme Court on a permissive appeal. And the issue deals with whether somebody who is on weekend incarceration is disqualified from receiving unemployment benefits. And both my program and the Defender Association wrote amicus briefs to support the court granting allowance of appeal in that case. We are still waiting to hear the outcome of that one. Policy work. There are a great number of issues that both of our offices are working on policy where we're able to be supportive of each other. The Chief Defender, Keir Bradford-Gray, runs the City Council Reentry Group. She had me testify on collateral consequences that Philadelphians experience. On the other hand, my organization is pushing a piece of legislation known as Clean Slate, which would automatically seal old misdemeanor convictions and non-convictions by using technology. A really promising bill with promising outcomes, and the Defender Association is supporting our work on that. Finally, we try to have some communications in common. We feature each other on social media and try to be partners in terms of getting the word out to the community about the work that we do. So I think that is an overview of how we have collaborated over the past decade or so, and I'm happy to answer questions later.
Hi, this is Rich Cazzola in Chicago at LAF, which used to be called the Legal Assistance Foundation, but that's still the way a lot of people around here know us. Catherine Huber, who was going to join me on this, got called into court on an emergency motion, and so she's not able to join us this afternoon. One of the things I think that I'll start off by saying is that a lot of what we have seen here echoes what Sharon in Philadelphia has seen. The juvenile court in Chicago, our office is downtown. The juvenile court is kind of in a challenging place to reach, even though it's only about 2 miles from Chicago. It's not really on any direct transit line, and it's kind of out where Jane Addams and the women of Hull House founded the juvenile court here back in 1898, the same area of the city. But we maintain a presence there at the juvenile court. So in some sense, Sharon's point about co-location is so we are there, and our partnership, which actually involves not just public defenders, but a number of other organizations, which I'll mention, being co-located at juvenile court, staffing a help desk for people has enabled us to get a lot of the benefits, I think, that she talked about in Philadelphia, because we have a presence out at juvenile court 4 days a week, and our other partner, Cabrini Green Legal Aid, which is a non-LSC provider, is out there 1 day a week. So I'll touch on a couple of those as I go through these, but the partners involve the presiding judge at juvenile court, which has really kind of been the staff of that office and the presiding judge have really worked to try to get everybody around the table to talk about eliminating some of the barriers. The clerk, which is involved with the filing of these petitions, The juvenile probation, which has, as time has gone on, and I'll explain, has really done a great job of steering and making sure that their clients know that we are there in the building. The Public Defender's Office, which has done the same. The State's Attorney's Office, just organizationally, even though the Prosecuting Attorney's Office has been exceptionally cooperative in working on issues of organizing the court and making it more efficient. As I said, we are a partner. Cabrini Green Legal Aid, which has been doing adult expungements for a long period of time, and recently, about 5 years ago, joined us on the juvenile expungements. Smart Chicago Collaborative, which is a kind of a tech partner in the foundation world, which helped us create a website, which I'll talk about. The Cook County Juvenile Justice Advisory Council, which is a function of the county, which has provided us some funding, and then DLA Piper here in Chicago, which has always coordinated a group of lawyers and other advocates in town in their pro bono practice around these issues. So we can go to the next slide. And so when we originally were here, there were a number of barriers, and this just lists some of them. So Northwestern also is and Julie Beal and the Juvenile Law Center there at Northwestern have also been helpful, and they did a report for the Illinois legislature last year, which has that statistic at the top. For every 1,000 juvenile arrests in Illinois, only 3 are expunged. We got involved at the Juvenile Help Desk on a very small basis about 10 years ago. We were staffing the help desk to help pro se litigants get records expunged, and we had a help desk and nobody was coming. And so the barriers that you see on here are what those were. People initially thought, I have a confidential juvenile record, why do I need to get it expunged? The requirements were confusing about how you would get them done. It would take you 4 or 5 trips to the juvenile court. You'd go out there, you'd learn you had to get your record. You'd have to go to a different part of the city to get your record if you were in Chicago. If you're in the suburbs, you'd have to go to the suburban police department to get your record. Then you'd come back to the court. You'd find out sometimes that the filing fee back then was as much as $60 per arrest, and then a $60 fee for notifying the police departments of things. They were unable to get the rap sheets off-site, so they would be making multiple trips back and forth. And then there was a concern that if somebody wasn't there on the day that they finally managed to get a petition filed and appear in court, that the expungements would not get entered. So that's 10 years ago. In 2007, so we started at the help desk with a VISTA position, and as I said, nobody showed up. And over time, we worked to eliminate these. So in the early days, Kate Winter, who is now over at Cabrini Green Legal Aid, was a VISTA here, and she kind of identified a number of the issues. And a partner that's not listed, Land of Lincoln Legal Services downstate, brought a case on adult expungements, a case called People versus People versus Lewis, to be able to use in Illinois what is a fee waiver petition, which later kind of evolved into just a statement from a legal services provider that somebody is below the poverty line, in a criminal expungement. And so the appellate court found and held that it was the expungement was a civil proceeding, and you could therefore get fees waived under that. We brought that to the attention of the juvenile court and the clerks, and early on in our history were able to begin to get fees waived. So that was the first step. Through a partnership with Smart Chicago, we eventually, there was funding that was provided for a rap sheet terminal at juvenile court, which enabled the public defender and we to send people to get fingerprinted to get their rap sheets at the court, which eliminated having to take the extra trips to the police departments in the suburbs. And in Chicago, we learned that we could get, for most people, a same-day rap sheet back. So people would come to the help desk, and as of about 2 years ago, we then send them to the probation department, which is able to give them, if you live in Chicago, almost instantaneously their rap sheet So they can then come back downstairs to the help desk and get the expungements completed. Cabrini Green joined in 2012 and has a wealth of experience on adult expungements. Because they're not an LSC provider, we are, they're also able to do legislative advocacy. We work together to come up with a way of how to track data about the people who are coming to the help desk. Where are they coming from? What are the issues that they're running into? And over the course of the last 3 years, Cabrini Green, on its own and in collaboration with other partners that they have, including the president of the Cook County Board, has successively, in bills that cover both adult expungements and juvenile expungements, removed a number of barriers. So at one point, you used to have to, if you had 14 juvenile arrests, and so in Chicago, there are things called station adjustments. If the police pick you up and you're at the police station, that creates a police record. And if you had 14 of those arrests, even though none of them made it to a juvenile court proceeding, you would have to file 14 different petitions with 14 different numbers and originally pay a $60 fee in each of the 14 cases in order to get them expunged. A bill that was passed by the legislature that went into effect at the beginning of this year consolidated all of those into being able to file it on one petition or in related petitions, which eliminated a great deal of paperwork. That was a bill that Cabrini and some of their partners worked on to achieve. Coming in the next year is a bill that provides automatic expungements for the vast majority of juvenile arrests and on findings. And so Cabrini has been able to do that on their own because they don't have the legislative restrictions that we do. But we talk about our cases regularly. And at the Juvenile Help Desk, because we staff it 4 days, they staff it 1 day, we've created mutual releases going back and forth so that if a client comes back, rap sheet doesn't come back on a day that we're there and Cabrini's there, they know that Cabrini's able to give that information to us so that we can work on a case and we can do vice versa. So there's been a sharing of data, there's been a sharing of experiences, and that, as Sharon points out, has led to other collaborations. And in one case, we were working on an amicus of an issue of a client of theirs that was going to be in the Illinois Supreme Court. Ultimately, the case resolved without needing to go there. But that's just one kind of collaboration that we have. We meet regularly. Cabrini has trained some of our lawyers on some of the areas that they do. If we specialize in employment, we have an employment practice group here. Cabrini generally doesn't, although they do employment-related issues on some of their expungement clients. And we're able to refer clients back and forth on certain issues. Cabrini has a history. I was a supervising attorney there in the 80s of having done criminal defense historically. While they still do criminal defense, they really focus on second chances for clients, and so they have a very robust expungement practice. So all of that collaboration has led to, one at a time, removing all those barriers that were on the first slide. Next slide. And this next sheet kind of shows how some of them were eliminated. The one-stop shop, you can now go out there and in 1 day, either pro se or if either Cabrini or we have capacity to do direct representation on that particular day for us to file on your behalf. More recently, in the last month, the court has run a pilot program of not requiring people to come up for their expungements, and that has led to positive advancements. So that, in other words, the court, in certain cases, will not use the fact that somebody is not there as the sole reason for denying an expungement, which allows then the expungements to be granted based on the initial filing, and so a lawyer doesn't have to be there on every court date either. Cabrini worked a great deal with input from us on new forms. We collaborated with the clerk on those, and those are now on the clerk's website, and they're the ones that we and Cabrini use. The new legislation, I talked about it. The legislation included a no-fee filing so that we no longer even have to file the fee waivers that we were able to use as a result of the case that Land of Lincoln filed downstate earlier in the year. We've developed for ourselves kind of an automated eligibility tool that kind of is a double check on the law students when they're doing expungements so that we kind of it enables you to kind of fill in the data about the client, and you get an answer back about whether that particular client is eligible or not. And Steve Pick in our office, along with our IT department, worked on that. And the next to last point is the one I mentioned about the project that has just begun in the last month. And it's also led each Cabrini and we to having especially robust partners with community organizations and with what are called in Chicago alternative schools, which are schools for kids who may not be succeeding in the regular school system and have had brushes with the law and are therefore in kind of a separate school. We also have internally at LAF a very active education practice that focuses on expungements, suspensions, disparate impact, and those issues. And so that's an area we specialize in that Cabrini doesn't. But they're on some broader policy issues. We're able to collaborate with them on issues in that area. Next slide. And then one of the things I think that our data collection has shown, because there was this myth that, oh, it's a juvenile expungement, it's really not hurting anybody. And so listed on this slide are the people, kind of categories of people who have come to the help desk with having encountered issues of not getting jobs, they believe, based on juvenile records. The challenge has always been in this area is when you then remove the barrier and the person's able to get a job, they're not so concerned about suing or initiating litigation. What they're really concerned about is the job. And so sometimes when some of the barriers are eliminated, even though I think as lawyers we would say, you know, this really was wrong, they shouldn't have had your record to begin with, the clients are more concerned about getting a job, getting something that's safe rather than raising an issue. The law that goes into effect next year has some provisions about a private right of action for clients whose expunged records are being used by employers. And so it'll be interesting in the coming year to see if that changes some of that calculus. But these are the kinds of categories of people who have come to us asking for expungements, oftentimes because they say that the employer or their licensing agency has somehow gotten a hold of their juvenile record. Next slide. That may be my last slide. There you go. All right.
Thank you, Rich. We're going to hear from Jamie now.
Good afternoon, everyone. I'm delighted to be with you on this, which is also my favorite day of the year. I hope you've all had a chance to dip into the office candy dish and get a little extra sugar today when it's supposed to be free. But I'm delighted to be here and to actually follow my two colleagues who just gave me a great education on expungement issues, because as part of my practice, that's a large part of what I do in the Community Defender Division. So I'm glad to hear that there are novel ways of doing that. So I expect that through this conversation, I'll be reaching out to coordinate some of these efforts. But today, I'm actually here to talk not so much about what I do in our Community Defender Division in our extension of the criminal practice, but more regarding how PDS ties our mission, which you can see there on that first substantive slide, ties our mission to serve indigent folks who are facing a loss of liberty in the District of Columbia as whole people. And so you can move to the next slide. One of the things that PDS prides itself in is working with folks not just on their criminal defense case. And many of you that have heard or met or have colleagues and friends that work at PDS know that we celebrate the fact that we are client-centered, or some of you may term it as holistic. And so PDS has looked at different ways for how we can address issues that go beyond the traditional criminal defense case. Next slide, please. And so one of the hallmarks of our practice is that we look at civil issues that our clients face not just as something that occurs after and that we don't need to be concerned at, but actually treat them as primary legal issues. For instance, I think one of the previous speakers was talking about how folks care sometimes so much more about what's going to happen next because of the implications of the criminal or juvenile case that they want that legal issue to be addressed. And so we focus energy on that. Next slide, please. So PDS itself has this model of client-centered representation and looking at our clients where they fit in all of the things or aspects of the system that touch them. And so we have social workers in our Office of Rehabilitation and Development. We actually have our own Civil Legal Services division that works on certain types of civil matters that arise out of our trial cases. And then we have my division, the Community Defender Division, which really is sort of the last stop in the criminal justice continuum, where we help folks, both juveniles and adults, who are incarcerated and returning home and facing issues and complications around their reentry. And so we work on those things. So PDS we have built in, but we also recognize that we're limited. And so what do we do when we can't directly serve our clients? Because one, we're not experts, right? We don't know all of these different civil areas of law that could impact our clients, and we don't have the capacity. While we're fortunate at PDS to be well-resourced and have lower caseloads than most public defenders in the country, we also don't have the capacity to take on all the civil matters. So what do we do? Next slide, please. We have been successul in DC in coordinating with building relationships with our community-based civil legal services partners. And there are many in DC, and they do amazing work. Some have found special niches like education or special education, issues arising out of human trafficking, and the list sort of goes on. And of course, there's the traditional issues such as housing and employment and family law. And so we meet with these folks in the community, we attend their meetings, and we share resources as well as referrals. But several decades ago, about 3 decades ago, folks in the civil legal services community realized that it's not necessarily the most efficient way to do things if folks are sitting in their silos and not communicating with one another because, one, the resources are limited, particularly for folks that are getting LSC funding, which PDS does not. And just because we want to make sure that the efforts are coordinated throughout the city so that folks are accessing services that they need where they're located. Next slide, please. So in 1989, a group of civil legal services providers came together to coordinate and found what's called the DC Consortium of Civil Legal Services Providers. And so you might ask, why is Jamie from the Public Defender Service talking about this organization? Well, PDS is actually a member. We weren't an original founding member, but we joined later on. But the beauty of this organization is it was founded by the now Dean, Shelley Broderick of the UDC David A. Clark School of Law, and another small group of civil legal services providers who found that alone they weren't able to reach our community. But together they would be able to have a greater voice, not only to address the individual service needs of the clients, but also on a policy level so that they could influence DC Council, the mayor, and eventually for us also the federal government where we can. Now, the latest information I have is that it's 34 organizations are members. That may actually be growing. There's a membership structure, and folks have to apply to become members. It's not complicated, but all of the members who are officially part of it vote. To accept folks that are focusing on this issue of expanding the availability and improvement of quality legal services to our poor and disadvantaged neighbors in the District of Columbia. Next slide, please. So this question, and I hope, I don't know necessarily the profile of everybody who's on this call. I hope it's a cross-section of civil folks as well as defense folks, because I think what we've heard from my colleagues when they were talking is it's so important to build these professional friendships with our sisters and brothers who are doing different types of work. And so my question that I sort of posed to myself and I pose to all of you is, why does it make sense for defender organizations or attorneys to belong to a civil legal services consortium? Well, here are sort of the main points. We meet on a monthly basis, and what that provides for us is an opportunity to share information. And even in a community and a jurisdiction such as DC, which is geographically small, there's so much information coming at us regarding potential bills before our DC Council, or other sort of local policy issues with, or subjects that are coming up with local organizations and agencies that impact our clients, what's going on in the neighborhoods that may be impacting, if there are trends. So when we come together, we're able to share that information in a collaborative way, and then we can identify who might be able to work on those issues. So that's one primary focus. Another focus is facilitating referrals. And I think this is, as we've heard from my colleagues, this is one of the primary benefits of having a consortium and why defenders should consider belonging to civil legal services organizations and vice versa. When we're able to facilitate referrals very quickly, then there isn't a break in service, and folks feel like the defense team is doing its job and the civil team is doing their job, and they may not even see a break in service. And I think that's extraordinarily important. And I loved the prior comment that we should be co-located or located nearby, because it's really important that folks know how to reach us. And, you know, if PDS is located down by the courthouse, but we're isolated from the civil legal services community, that may not be as helpful to getting people literally to walk into our doors. And so, for instance, the community defender office, we are located in the community, closer to where our clients may find it easier to meet us outside of going down to the main office, which is near the courthouse, because that adds stress and time and money and things like that. The third aspect we're highlighting here is professional development and continuing legal education. One of the benefits that I have seen in my few years of representing PDS in the consortium is that this organization does an amazing job of training everyone who is a member organization, as well as its staff, and coordinating trainings, as my colleagues were discussing, how maybe one organization is an expert on X issue, so they train folks, whether that's to promote the facilitated referrals, or if it's to promote the work to be done directly in another organization. And I think that's really important. It sort of goes along with coordinating information, but when we're trained on those legal issues, it expands the knowledge base of the attorneys and staff. And then finally, particularly for defense attorneys, the responsibility to our clients to understand what the collateral consequences are and what happens if we don't address them. I mean, obviously, Padilla raised the issues of immigration, and I'm not an immigration attorney, and I will work with immigration law firms when we need to. But it's important for us to understand that the arrest can impact all those things that our friends in Chicago were talking about. If your record is available, then it could impact how you're going to get a job, whether or not you're barred from certain housing, whether or not you can serve in the military. And as a lawyer and as a defense attorney, if I'm advising someone to take a plea, or if we lose at trial, what are those next phases of that person's life, and how is everything going to unfold for them? And they may be concerned about a host of things. And if I don't practice in those areas myself, I can use the resources of the consortium to reach out to folks who I know can help, and they often, and I would say almost always, will find a way to help me. And that includes my clients who are incarcerated in the Bureau of Prisons and very far away from us, because in DC we don't have a local prison system. Next slide, please. So the consortium itself is has come a long way since 1989. As I mentioned, it was a small group that sort of met at the law school back in its early days, but now it's sponsored by one of the big law firms here in DC, and we meet monthly. And through its hard work of the member organizations, it's developed several great studies and reports and this centralized referral system, which is the first thing I referenced here on the slide. The lawhelp.org/DC is a website where if you're looking for a certain type of help on a legal issue, you can go to that website and look at the organizations and see who might be able to assist. And that's extraordinarily helpful, not only for member organizations, but also for potential clients out in the community and our neighbors. And so it's a great organization, and it gets many, many hits for folks looking for services. So that's an excellent resource. Back in 2005, the consortium was one of the main actors that helps to advocate for the DC Access to Justice Commission and its establishment. And while I couldn't find a lot of the history of that, what I will say is the members of the consortium themselves were conducted meetings and did research and helped to influence so that the district would create this Access to Justice Commission. And as you know, it's just because I sit in the public defender service, I often get accused of being a civil legal services lawyer stuck in a public defender or vice versa. But you know, access to justice for folks on the civil side is such an important issue for all of us serving poor and disadvantaged folks. And so this issue is, we champion this, and folks from the DC Access to Justice Commission come to our monthly meetings in the consortium. In 2009, there was a report that was issued, the research conducted a report on rationing justice. And I attached at the end, there's a resource list. You can link to these documents. But it's important to see, you know, what's going on in the district and why aren't things being funded so that folks can access these services. So it's really an extension of that same mentality of us looking at why are the resources so limited for folks in DC who are seeking assistance in the civil legal services realm. And then most recently, just last year, the consortium conducted a community listening project, and I have no direct involvement in this. This is really the large, very heavy lift by our civil legal services partners who went out to the community, conducted surveys, and came up with recommendations of how we could best serve our community. And this includes how to get resources to the community, how to get involve the community in community engagement, what things we need to be promoting out in the neighborhoods regarding civil legal services. And so I encourage you, if you have time and you're looking to compare and expand these types of ideas, or maybe implementing something similar in your jurisdiction, to read the report or parts of it, and then reach out to our consortium coordinator, which I'm happy to link you to, or to whom I'm happy to link you to learn more about how that project is going to be influencing our work moving forward. For instance, I have committed to assisting the consortium on the community engagement piece, because that's what I am. I'm a community defender, and so I want to be able to figure out how we can get the community, not only are we invested in them, but how they can in turn invest in us, and so that we can move forward with an aligned vision for what our community needs. Next slide, please. So here is a list of references. I had a little bit of fun playing with our new PowerPoint, but they're all links, and I'm sorry I wasn't smart enough to figure out how to do the hyperlinks in the text itself, but feel free to link onto any of those, and if for some reason you can't, I'm happy to provide more resources. And if you have questions specifically about the consortium and how